We will now proceed with the consideration of the outcome on Australia based on the report of the Universal Periodic Review Working Group on Australia as contained in documents A/HRC/17/10 and A/HRC/17/10 Addendum 1. This report and its addendum, together with the additional information that will now be provided by Australia, will constitute the outcome of the review and shall be adopted by the Council through a standardized decision. I will now give the floor to His Excellency Mr. Peter Wolcott, Ambassador and Permanent Representative of Australia to the United Nations in Geneva, to present the additional information on the review. Ambassador, you have the floor.
Thank you, Mr. President. At our Universal Periodic Review on 27 January, Australia received 145 recommendations from some 53 countries. At the adoption of the draft UPR Working Group report, the Australian Government committed to consulting with a broad range of stakeholders before providing a detailed response at this session of the Human Rights Council. Since January, the Attorney-General has led an extensive consultation process to determine Australia's position on the recommendations. In March, the Attorney-General and Senator Kate Lundy, who led the Australian UPR delegation, tabled the draft UPR Working Group report in the Australian Parliament. The Australian Government has consulted across government, including with the states and territories. The Australian Government has also participated in a number of meetings with the Australian Human Rights Commission, non-government organisations and civil society to discuss the UPR recommendations and our response. I would like to take this opportunity to thank the Australian Human Rights Commission and non-government organisations for their constructive engagement throughout the consultation phase. We welcome the commitment and energy brought to the UPR process by Australia's human rights community. Today, Australia presents its response to the 145 recommendations made during its interactive dialogue. In total, Australia will accept, or accept in part, 94%. That is, 137 of these recommendations. Our response was submitted to the UPR Secretariat on 27 May and is available as an addendum to the report of the Working Group. In addition, the Australian Government would like to take this opportunity to announce that it intends to provide the Human Rights Council with an interim report prior to its next UPR. At the adoption of the draft UPR Working Group report, we identified the key focus areas raised by delegations in Australia's UPR as follows. First, Australia's ratification of additional international human rights instruments. Second, domestic legal protections. Third, the rights of Indigenous peoples. Fourth, combating racism and promoting tolerance. Fifth, violence against women and children. Sixth, rights of persons with disability. Seventh, refugee and asylum seeker policies. And eighth, Australia's counter-terrorism measures. Since the Australian delegation appeared before the UPR Working Group in late January, a number of important developments have occurred in each of these areas. In the context of providing our response to recommendations, the Australian Government would like to highlight some of these recent developments. They demonstrate the Australian Government's continuing commitment to the promotion and protection of human rights. A number of UPR recommendations made to Australia related to Australia's international human rights obligations and domestic implementation of those obligations. At our UPR, the Australian Government committed to using accepted recommendations to inform the development of Australia's new National Human Rights Action Plan. Preparation of the National Human Rights Action Plan is well underway and a draft will be released for public consultation later this year. Progress has also been made in developing an education and training program for Commonwealth public servants to raise awareness and understanding of Australia's international human rights obligations. The program will be delivered through face-to-face seminars, workshops and a dedicated web page. As an additional element of Australia's human rights framework, legislation is currently before the Parliament that will establish a Parliamentary Joint Committee on Human Rights. The bills will establish mechanisms designed to encourage early consideration of human rights in the development of policy and legislation. In particular, they will require new legislation to be accompanied by a statement of compatibility with Australia's human rights obligations in the 7 core United Nations human rights treaties to which Australia is a party. At its UPR in Geneva, the Australian Government noted its intention to review and consolidate federal anti-discrimination laws, as well as introducing legislation to formally protect against discrimination on the basis of a person's sexual orientation or gender identity. Policy work and drafting have commenced, and draft legislation will be released for public consultation later this year. Mr. President, a number of UPR recommendations made to Australia related to the rights of Indigenous peoples. A recent development in this area is the election in April this year of the co-chairs of the National Congress of Australia's First Peoples. The National Congress of Australia's First Peoples is a national representative body for Aboriginal and Torres Strait Islander peoples. The establishment of the National Congress acknowledges the importance of Indigenous peoples being closely involved in the development and implementation of policies and programs that impact upon them. The National Congress will provide a central mechanism with which governments and the corporate and community sectors can engage and work on reform initiatives. It will bring to the table an informed and strong national voice for the goals, aspirations, interests and values of Aboriginal and Torres Strait Islander peoples. The new co-chairs will continue to develop the National Congress ahead of its first meeting in June this year. Mr. President, combating racism and promoting tolerance. There are a number of UPR recommendations in this regard. The Australian Government remains committed to ensuring that all Australians respect racial equality enshrined in our law, and that Australians of all cultures have the opportunity to participate fully in Australian society. A recent development in this area is the February 2011 launch of Australia's new multicultural policy entitled The People of Australia. The multicultural policy affirms Australia's commitment to a just, inclusive and socially cohesive society, and shows that the government is unwavering in its commitment to a multicultural Australia. The new multicultural policy recognises that Australia is a multicultural nation. Since 1945, 7 million people have migrated to Australia. Today, a quarter of Australia's 22 million people were born overseas, 44% were born overseas or have a parent who was, and 4 million speak a language other than English. Australia is and will remain a multicultural society. The multicultural policy outlines key principles designed to strengthen Australia's social cohesion and combat racism. It also establishes practical initiatives, including the establishment of the Australian Multicultural Council as an independent body which will advise government on multicultural issues, a new national anti-racism partnership and strategy, and a multicultural youth sports partnership program. The policy also strengthens the access and equity framework to ensure that all government services are responsive to the needs of Australia's culturally diverse communities. A number of UPR recommendations made to Australia related to counter-terrorism measures and efforts to ensure compliance with international obligations in this respect. A recent development in this area is the appointment in April this year of Australia's first independent national security legislation monitor. The Independent National Security Legislation Monitor will review the operation, effectiveness and implications of Australia's counter-terrorism and national security legislation. The Monitor will report to the Prime Minister and the Parliament on an ongoing basis. Mr. President, a number of UPR recommendations made to Australia related to the rights of women and the rights of children. A recent development in this area is the endorsement in February this year of the National Plan to Reduce Violence Against Women and Their Children by the federal, state and territory governments. The National Plan is a single, unified strategy that brings together government efforts to reduce violence against women and their children. It focuses strongly on prevention, including building respectful relationships amongst young people and working to increase gender equality to stop violence from occurring in the first place. This is the first plan to coordinate action across jurisdictions. It is the first to focus strongly on prevention. It is the first to look to the long term, building respectful relationships and working to increase gender equality to prevent violence from occurring initially. It is the first to focus on holding perpetrators accountable and encouraging behaviour change. Key actions under the National Plan include supporting local community action to reduce violence against women, new programs to stop perpetrators committing acts of violence, the introduction of an innovative social marketing campaign called, and I quote, "The Line," unquote, which is designed to influence young people's relationship attitudes and behaviours, the establishment of a national telephone online crisis support service for anyone in Australia who has experienced or is at risk of sexual assault and/or domestic and family violence, establishing a national centre of excellence to evaluate the effectiveness of strategies to reduce violence against women, and setting up an inquiry into the impact of federal laws on those experiencing family violence. Australia also received UPR recommendations regarding equal employment participation and pay equity for women. A recent development in this area is the announcement in March this year of reforms to the Equal Opportunity for Women in the Workplace Act of 1999. These reforms will modernise the law and require large employers to report on gender equality outcomes, including the gender composition of their organisations and their boards, pay equity, and on the availability of flexible work arrangements for men and women. Mr. President, a number of UPR recommendations made to Australia related to the rights of persons with disabilities. A recent development in this area is the endorsement in February of this year of the National Disability Strategy by the federal, state and territory governments. This is the first national strategy to provide a long-term roadmap for improving the lives of Australians with disability. It sets a 10-year reform plan for all governments to address the barriers faced by Australians with disability and will ensure that mainstream services and programs, including healthcare, housing, transport and education, address the needs of people with disability. The strategy is a product of extensive consultation across the country. More than 2,500 people with disability and their carers had their say in its development. A further development has been the implementation of new building accessibility standards, which commenced in May of this year. These standards will ensure all new and upgraded public buildings in Australia will be accessible to people with a disability. Providing better access to public buildings will remove a significant barrier for people with a disability in accessing services, employment and taking part in the community. Mr. President, a number of UPR recommendations made to Australia related to the rights of migrants, asylum seekers and refugees. A recent development in this area is the introduction of new legislation in February of this year to enshrine non-refoulement obligations in law. Existing processes require the personal intervention of the Minister to ensure compliance with non-refoulement obligations under the International Covenant on Civil and Political Rights, the Convention Against Torture and the Convention on the Rights of the Child. The new complementary protection legislation will provide for the grant of a protection visa in circumstances that engage Australia's non-refoulement obligations under human rights treaties other than the Refugee Convention. This will allow for greater certainty and faster outcomes for vulnerable people at risk of violation of their fundamental human rights. Australia also received UPR recommendations regarding children in immigration detention. At its UPR, the Australian Government referred to an expansion of its existing residence determination program to enable significant numbers of minors and vulnerable families to move from immigration detention facilities into community-based accommodation. The Government has made a commitment that the majority of children will be moved into community-based accommodation by the end of June 2011. The Australian Red Cross is the lead agency for the implementation of these expanded residence determination arrangements and will draw on the expertise of a wide range of experienced service providers and contributing organisations. In conclusion, Mr. President, the Australian Government has given serious consideration to each of the recommendations made during its UPR. We openly acknowledge the existence of human rights challenges in Australia. We view the UPR as an occasion to reflect on those challenges, and we renew our commitment to continue to work to strengthen our human rights protections. Importantly, the Australian Government does not consider its engagement with the UPR process ends with the submission of our response to the recommendations today. In many ways, this signals the beginning of Australia's longer-term engagement with the UPR process as part of Australia's enduring commitments to human rights. On behalf of the Government of Australia, I would like to conclude by thanking the President and Member States of the Human Rights Council and the UPR Secretariat for their involvement in Australia's first UPR. Thank you, Mr. President.
Thank you. I thank the Ambassador for his statement. Before opening the floor, I'd like to remind all of you that speaking time has been brought to 2 minutes for all, and I will now give the floor to Thailand.
President, there must have been some technical problems. Sorry.
I will now give the floor to the Lao People's Democratic Republic.
President. Mr. President, the Lao delegation warmly welcomes the delegation of Australia to the 7th session of Human Rights Council and wish to express our appreciation for the comprehensive presentation, including updated information in the area of promotion and protection of human rights that has been taking place in Australia. Its report has demonstrated remarkable progress and commitment in various areas relating to human rights. We commend the Australian government that accepted a large number of recommendations put forward by member countries during the UPR process. We take note with appreciation that Australia continues to place broad range of law, policies and programs to respect, protect and promote human rights. These include closing gap in the opportunity of life outcome between Indigenous and non-Indigenous Australians, achieving gender equality and reducing violence against women. Mr. President, the Australian government has clearly demonstrated its committed engagement with the UN mechanism and international community toward the further promotion and protection of human rights in the country. We also note the Australian government's commitment to implementing the Millennium Development Goal and working with the government and peoples of developing countries to deliver aid where it is most needed and most affected. My delegation therefore proposed that the report of the working group for Australia be adopted. Thank you, Mr. Chairman.
Thank you. I give the floor to Timor-Leste.
Thank you, Mr. President. Timor-Leste welcomes Ambassador Woolcott and his delegation to the 17th session of the Human Rights Council. We thank Australia for the consideration and responses given to the submission made during its review. We note with appreciation that Australia has accepted most of the recommendations during its UPR. We respect Australia's position not to accept the recommendation regarding legal protection of irregular migrants. We also respect the rationale provided for it. However, as a close friend of Australia, we are compelled to remind that being dislodged from their homes, the irregular migrants are first and foremost in need of assistance and protection. In this regard, we commend the recent changes in Australia's policies towards unaccompanied children and asylum seekers, as well as for the information just provided in this presentation of changes in connection to protection of asylum seekers. In the meantime, with the strong commitment to human rights and with the implementation of accepted recommendations, we believe that Australia will make further advancement in the promotion and protection of human rights. We therefore recommend that Australia's outcome report, the outcome report of Australia's UPR be adopted. Thank you, Mr. President.
Thank you. I give the floor to Algeria.
Mr. President, we extend a warm welcome to His Excellency the Ambassador of Australia and his delegation, and thank him for his presentation. We value the views it expressed, the delegation expressed on the conclusions and recommendations Australia received on the occasion of the review of its national report. My delegation wishes again to praise Australia for its long tradition of promoting and protecting human rights, and for having had the vision and courage to apologize to the harm done to Aborigines. This should inspire similar actions from violators of human rights of indigenous people across the world. The active role being played by the Australian delegation in the Human Rights Council translates this tradition. One of the 2 accepted recommendations made during the interactive dialogue by the Algerian delegation was in favor of strengthening further the measures to combat discriminations against minority communities, including Muslim communities. We appreciate that Australia's new multicultural policy includes a national anti-racism partnership and strategy, the establishment of the Australian Multicultural Council, a multicultural ambassadors program, and a multicultural youth sports partnership program. As for the second Algerian accepted recommendation, we are fully satisfied by the Australian government's commitment to increase the official development assistance until it reaches 0.7% of GNI. Algeria recommended to Australia acceding to ICRMW. We still hope that Australia will reconsider its position on this issue. We recommend the Council to adopt the report of the Working Group on the UPR of Australia, to whom we wish success in the implementation of the accepted recommendations. Thank you.
Thank you. I give the floor to the Republic of Moldova.
Mr. President, first of all, we would like to express our thanks to His Excellency Ambassador Woolcott for his complimentary inputs on the recommendations made by the Working Group of the Universal Periodic Review during its 10th session. The Republic of Moldova re-acknowledges Australia's long traditional engagement with the international community in the development of the international human rights system. We welcome the Australian government commitment to consulting with a broad range of stakeholders before providing a detailed response to the UPR Working Group report by the Human Rights Council at this session. We welcome the acceptance of the significant number of the recommendations by Australia. During the interactive dialogue of the 10th session, our delegation made some comments and submitted 3 recommendations. We appreciate Australia's acceptance of our recommendations. The Republic of Moldova welcomes Australia's commitment to ratify as soon as possible the optional protocol to the Convention Against Torture or other cruel, inhuman and degrading treatment or punishment. We acknowledge the decision of the Australian government to ensure that all procedures, including those relating to terrorism, are in accordance with its international obligation in terms of fair trial. We express our satisfaction with Australia's commitment to draw up a general framework introducing measures to ensure equality of rights for persons with disabilities. We commend the Australian government for its commitment to providing an interim report to the Human Rights Council prior to its next UPR. We wish to Australia success in the implementation of the recommendations it has accepted, and we recommend to the Human Rights Council to adopt the Australian report. Thank you, Mr. President.
Thank you. I give the floor to the Islamic Republic of Iran.
Mr. President, we have taken note of this statement delivered by the delegation of Australia with regard to UPR outcome report of the country. However, we still remain deeply concerned over a number of human rights violations in Australia, reflected through various recommendations made by states during UPR working group, including emerging new forms of racism and Islamophobia in the Australian society, violation of human rights of migrants, refugees, and asylum seekers as a result of hardline immigration policies, restriction against indigenous people, in particular against indigenous women and children, especially with regard to access to appropriate health and education services, using harsh force and taser by police against various groups of people. Mr. President, finally, we call upon Australian government to take into account the legitimate concerns expressed by international community seriously and take effective legal and practical measures to address them promptly and in an efficient manner. I thank you, Mr. President.
Thank you. I give the floor to New Zealand.
As a fellow member of the Pacific Islands Forum and a close friend and neighbour, New Zealand welcomes the delegation of Australia today for the adoption of the Universal Periodic Review. On the 27th of January this year, New Zealand took part in the UPR of Australia, making several recommendations, including that Australia ratify the optional protocol to the Convention Against Torture, establish a Children's Commissioner to monitor compliance with the Convention on the Rights of the Child, introduce federal law that prohibits discrimination on the grounds of sexual orientation, and improve its approach to investigating and preventing deaths in custody. Australia has accepted in full or in part the majority of New Zealand's recommendations, and we welcome this commitment. Australia consulted widely, including in remote communities, when preparing its national report. The consultation received 35,000 submissions, indicating a high level of support and public engagement. Australia has taken the innovative step of tabling concluding observations from treaty bodies and the Universal Periodic Review recommendations in its Parliament. The UPR recommendations that the Government has accepted will inform the development of the updated National Human Rights Action Plan. Australia has acknowledged that Aboriginal and Torres Strait Islanders are amongst the most disadvantaged Australians. New Zealand welcomes Australia's stated goal of advancing the social and economic rights of its Indigenous peoples and notes that Australia has developed specific targets for this work. New Zealand also acknowledges the development of Australia's new multicultural policy. Thank you very much.
Thank you. I give the floor to Morocco.
Thank you, sir. I would first of all like to congratulate the Australian ambassador for his introduction to his country's position on the recommendations from the UPR held in January this year. My delegation particularly welcomes the serious approach, the transparency and the openness shown by the government of Australia throughout the UPR process. Kingdom of Morocco would like to commend Australia for its commitment to the recognition of respect for and the promotion of fundamental rights of all Australians without any discrimination, as we can see in the national report and was confirmed during the review. We also congratulate the Australian government on all the progress achieved for the rights of Indigenous peoples and measures intended to improve their socio-economic conditions. This is testimony to the resolve shown by the country to complete the building of a multicultural society based on the principles of tolerance, diversity and inclusiveness. Turning to recommendations emerging from the UPR, my delegation is particularly satisfied that the 3 recommendations made by Morocco during the UPR enjoy Australia's support, particularly 1, the strengthening of federal legislation to combat discrimination and its effective implementation in order better to protect the rights of the vulnerable population, particularly children, detainees and persons with disabilities. 2nd, continued efforts to promote multiculturalism and social integration. And 3rd, strengthening efforts to promote the representation of Indigenous women to decision-making positions. Finally, my delegation is firmly convinced that the Australian government will spare no effort to implement all of the recommendations that the country has accepted. Thank you.
Thank you. I give the floor to Belgium.
Thank you very much, President. Belgium wishes to thank the delegation of Australia for its addendum to the working group report, or to the report submitted to the working group, and thank it for its presentation today. The earnest and transparent manner with which Australia underwent the UPR process heralds even greater merit in future, particularly regarding the implementation of the recommendations. There are 2 recommendations submitted by Belgium amongst these, one regarding discrimination against Indigenous peoples and the other regarding compliance of certain anti-terrorist measures with Australia's human rights commitments internationally. We thank the Australian authorities for having duly considered these recommendations and hope that there will be a positive outcome. My delegation wishes to come back to the third recommendation that it had submitted during the working group. This recommendation invited the Australian authorities to repeal the legal provisions authorising the sterilisation of people with disabilities without their consent and for non-therapeutic reasons. In its addendum, the Australian government indicates that it partially accepts this recommendation, specifying that it believes the best interests test as applied in Australia, and that this does comply with international commitments of the country. Could the Australian delegation specify in what this test consists on and how it's applied? There are concerns that have been expressed in this regard, both internationally and within the country. The Attorney General has already begun discussions with his counterparts within the states and the territories, and we hope that this dialogue will be able to allay all concerns in this regard. Allow me, President, to conclude my statement by thanking Australia for an excellent UPR and for wishing them all the best in the implementation of recommendations. Thank you.
Thank you. I will now give the floor to national human rights institutions and NGOs, starting with the Australian Human Rights Commission.
Mr. President, this statement is made on behalf of the Australian Human Rights Commission, Australia's A-status national human rights institution. The Commission welcomes the report of Australia's appearance in the UPR process and the government's response to the recommendations. The government is to be commended for its frank and robust engagement in the UPR process, both in the formal working group session and in engaging with the Commission, NGOs and civil society throughout the process. The Commission warmly welcomes the voluntary commitments made by the government during the UPR process, including incorporating all accepted recommendations into Australia's forthcoming National Action Plan on Human Rights, and making an interim report to the Human Rights Council prior to Australia's next UPR appearance. The Commission looks forward to working with the government to ensure that these commitments make a substantial impact in improving the protection of human rights in Australia. Mr. President, the Commission welcomes the government's acceptance of recommendations to progress ratification of OPCAT and to ensure appropriate conditions in detention. However, the Commission has released numerous reports expressing concern about the conditions in immigration detention facilities, the excessive timeframes for which people are being held in detention, the mental health impacts of indefinite detention, and the ongoing detention of hundreds of children in immigration detention facilities. The Commission has consistently stated that the current system of mandatory and indefinite immigration detention is not in compliance with Australia's international human rights obligations, and we continue to urge the government to reform the system accordingly. The Commission welcomes the government's acceptance of recommendations 122, 124 and 125. We see these recommendations as including that any arrangement for regional processing of asylum seekers will fully comply with the Refugee Convention and Australia's human rights obligations. Mr. President, the Commission will continue its role of monitoring and advocating for improved human rights protections in Australia, including in relation to immigration matters and other recommendations not accepted by the government at this time. I thank you.
Thank you. I now give the floor to the European region of the International Lesbian and Gay Federation.
Thank you, Mr. President. This statement is made on behalf of the Australian Coalition for Equality, an NGO dedicated to achieving equality for lesbian, gay, bisexual and sex and gender diverse Australians in national law and policy. We join other NGOs in calling upon Australia to introduce a comprehensive Human Rights Act and to enact legislation addressing systematic discrimination and promoting substantive equality. We applaud the considerable steps taken by the Australian government to provide equal treatment of same-sex partners in de facto marriages. However, we are extremely disappointed Australia maintains its policy of not recognising legitimate same-sex marriages performed in other countries. we note Australia has rejected a recommendation to amend its Marriage Act to allow same-sex partners to marry. Several recommendations relate to the introduction of national anti-discrimination laws, and we welcome Australia's policy commitment to include protections for people of a diverse sexual orientation, sex and gender identity. We remain concerned Australia has not committed to include same-sex partners within anti-discrimination policy and fails to ensure people who identify as intersex will be protected as well. Further, we urge that these laws and policies be implemented in line with the Yogyakarta principles of applying international law in relation to sexual orientation and gender identity. Only last month, Australia's Parliament passed an amendment to national sex discrimination laws, legislating that states and territory laws were not being discriminatory if they required a gender-diverse person to divorce before updating their birth certificate with their affirmed gender. Yogyakarta Principle 3 states all people have the right to recognition before the law, and that no status, such as marriage or parenthood, may be invoked to prevent the legal recognition of a person's gender identity. Finally, we call on Australia to reconsider its position on marriage equality and to make public commitments to introducing anti-discrimination laws and policies in accordance with the Yogyakarta Principles. Australia has come a long way in its treatment of lesbian, gay, bisexual and sex and gender diverse people since the 1994 Toonan and Australia case, where homosexuality was still illegal in the state of Tasmania. But much remains to be achieved in legislative, policy and programme areas to ensure equality for Australians of a diverse sexual orientation, sex or gender identity. I thank you.
Thank you. I give the floor to Human Rights Watch.
Thank you, Mr. President. Human Rights Watch welcomes the Australian support for the recommendation by Sweden to safeguard the rights of refugees and asylum seekers. However, we remain deeply concerned that the government's current and prospective policies and practices may in fact run afoul of Australia's international obligations. For example, Australia is currently pursuing an agreement with Malaysia under which 800 asylum applicants will be forcibly transferred to Malaysia in exchange for 4,000 recognized refugees from Malaysia. The agreement appears to lack necessary guarantees that they will be treated in accordance with Australia's international obligations. Malaysia is not a party to the Refugee Convention and has a poor track record of treatment of irregular migrants. This violates Australia's obligations under CAT and other international treaties. We call on the Australian government to abandon such bilateral agreements. We also acknowledge that Australia has accepted in part several recommendations on the mandatory detention of asylum seekers, including recommendations from Norway and Brazil. But we regret that it rejected a recommendation from Switzerland not to detain migrants other than in exceptional cases. The Australian government claimed during the UPR that immigration detention is used only as a last resort and for the shortest practicable time. In rejecting Switzerland's recommendation, the government claims that mandatory detention is based on unauthorized arrival and not on individuals seeking asylum. However, the reality is that asylum seekers, including children, face mandatory and indefinite detention as a matter of course before other options have been exhausted. As of May 13, 2011, there were 6,730 people in immigration detention facilities in Australia, of which 6,079 are undergoing refugee status assessments. Australia has also accepted in part Brazil's recommendation number 129, but Australia's claim that it will not detain children is based on a policy under which children will not be detained in particular high security facilities. More than 1,000 children are currently detained in other secure immigration detention facilities. To conclude, we urge the Australian government to end mandatory detention of all asylum seekers. Australia should enact legislation providing that asylum seekers are not only detained when strictly necessary and as last report, and that children should never be routinely detained. We urge you to set time limits on immigration detention, provide for regular judicial reviews of a person's detention, and to ensure that all detainees have adequate access to legal counsel, interpreters, communication facilities, education, physical and mental health services, and religious support networks. Thank you for your attention.
Thank you. I give the floor to Sudwink.
Thank you, Mr. President. Despite the Australian government's new direction policy to use detention of asylum seekers only as a last resort and for the shortest practical time, for Sudwin, the dramatic increase of people held in immigration detention for indefinite and unnecessarily extended periods remains a matter of major concern. Australia is the only country in the world with a mandatory, not time-limited and non-reviewable detention system, which under the National Migration Act detains all unauthorized arrivals, including children. This clearly violates the right to liberty and prohibition of arbitrary detention enshrined in Article 9.1 of the ICCPR and Article 37B of the CRC. As a matter of priority, Sudwind urged Australia to end the current system of mandatory and indefinite immigration detention and to incorporate its international human rights obligation into domestic law through the adoption of a Federal Human Rights Act. Until this has not turned into reality, Australia is urged to fully comply with its key detention values, especially in regard to asylum seekers arriving by boat, make greater use of community-based detention for the vast majority of asylum seekers, particularly for the most vulnerable, stop third country processing, and to amend immigration detention law to fully comply with the Convention on the Rights of the Child, including special protection and assistance for unaccompanied minors. Sudwind welcomes the recent announcement of a comprehensive parliamentary inquiry into Australia's immigration detention system and expects serious reform with a thorough follow-up process. Moreover, the government's decision to reject the recommendation to establish a national compensation scheme for the stolen generation will be devastating for Aboriginal and Torres Strait Islander people. This rejection disregards Aboriginal and Torres Strait Islander people fundamental right to equality before the law and the right to restitution for past wrongs. Thank you, Mr. President.
Thank you. I give the floor to the Indian Council of South America.
Thank you, Mr. Chair. The Declaration on the Rights of Indigenous Peoples cannot be the sole basis for addressing the wrongs of the past and the continuing challenges to address the denial of the rights of Australia's First Peoples to their territory and resources and for their protection against abuses. In consulting with grassroots, there still remains doubt that the National Congress of Australia's First Peoples will not do, quote, business as usual, unquote, and be used as a rubber stamp mechanism like the BIA in the United States of America. Many Western-based countries have imposed doctrines of dispossession according to the Land Rights Report of Eric Gadias. And these doctrines of superiority are still in operation, and they still are used in many countries. While your government accepted in part Recommendation 24 concerning the Racial Discrimination Act of 1975, stating that it supports the promotion of and respect for the principles of the Declaration of Rights of Indigenous Peoples, we strongly disagree and reject the notion that this will not amount to continuing denial of the rights of Australia's First Peoples on the ground. Australia has yet to implement the recommendations of the Special Rapporteur on the rights of Indigenous peoples. Does the current federal laws consistent with the spirit of the Declaration mean that you will only implement them in spirit, or will you materially implement the obligations? Many layers of conditional recognition protection of the right to self-determination must not amount to lip service in realizing the right to development. The government's decision to reject the establishment of a national compensation plan for stolen generations is not acceptable. This disregards the equality rights and the equal rights before the law. I thank you, Mr. Chair.
Thank you. I give the floor to the Islamic Human Rights Commission.
Mr. President, the Islamic Human Rights Commission would like to raise their concern in regards to the alienation, marginalization experienced by Muslim citizens of Australia, as well as the Government of Australia's suspension on processing new asylum claims for Afghan and Sri Lankan nationals, which is fundamentally inconsistent with Australia's international obligations under the 1951 UN Refugee Convention. The Muslim population living in Australia are facing serious prejudice and hostility, Incidents such as headscarves being pulled off women and attacks on Muslim organizations are common. Australia must abide by their obligations under the Convention on Elimination of Racial Discrimination by protecting its citizens. Furthermore, over 90% of asylum seekers who arrive in Australia are found to have genuine protection claims. However, their claims are being dealt with very slowly, whilst they are living in appalling conditions in Australian immigration detention centres, where 5 suicides have been reported. The Australian government must implement the internationally agreed criteria set out in the 1951 Refugee Convention, under which individuals who are found to be at risk of torture, persecution or death are offered protection when seeking asylum. The Islamic Human Rights Commission urges the Government of Australia to take action in preventing any further attacks and abuse on the Muslim minority. Furthermore, the Government of Australia must put an end to the suspension of processing asylum cases and not override the rights of the most vulnerable. Thank you, Mr. President.
Thank you. I give the floor to the National Association of Community Legal Centres.
Thank you, Mr. President and Ambassador Woolcott. This statement is on behalf of 68 NGOs, including the Human Rights Law Centre, the National Association of Community Legal Centres and Kingsford Legal Centre. We welcome Australia's acceptance of the vast majority of UPR recommendations, including the commitment to enhance anti-discrimination laws and to consider increasing overseas development assistance to 0.7% of GNI. We also welcome the commitment to provide the Council with an interim report and to incorporate UPR recommendations into the National Human Rights Action Plan. We regret that Australia's response in some areas does not accurately reflect law, policy or practice. For example, there is no Australian jurisdiction in which police-related deaths are independently investigated. Australia does not have mechanisms to systematically review and implement recommendations from UN human rights bodies. And mandatory, indefinite, arbitrary immigration detention is a fact, both in law and practice. We also regret that Australia's response does not meet the need for legal and institutional reform to address many of the persistent issues documented by UN human rights bodies, the Australian Human Rights Commission and NGOs. In accordance with this need, Mr. President, we call on Australia to, first, incorporate international human rights into domestic law through a comprehensive Human Rights Act. Second, strengthen laws to address systemic discrimination and promote substantive equality. Third, fully implement the Declaration on the Rights of Indigenous Peoples and all of the recommendations of the Special Rapporteur. And fourth, legislate to ensure that asylum seekers are detained only where strictly necessary and as a last resort, that no children are held in immigration detention, and that all asylum seekers have equal access to and protection under law. Australia is a democratic, developed state with a good human rights record overall, and a government which espouses a commitment to human rights leadership. Despite this, there are significant gaps in the legal protection and practical realisation of human rights. Mr. President, the time has come for Australia to move from the rhetoric of best practice in engaging with human rights mechanisms to the reality of best practice in implementing human rights obligations. We look forward to working with the government to achieve this. Thank you, Mr. President.
Thank you. I give the floor to Amnesty International.
Mr. President, Amnesty International welcomes Australia's positive engagement with the UPR, including the national consultation undertaken beforehand. We are pleased that Australia has accepted the majority of the recommendations. We regret that Australia has rejected recommendations to introduce a Human Rights Act, which is necessary to embed Australia's international human rights obligations in national law. Further, we are concerned that the Racial Discrimination Act of 1975 has only been partially reinstated and provides no retrospective rights in the Northern Territory. We regret that Australia has rejected the recommendation to allow same-sex marriages. Mr. President, Amnesty International has repeatedly raised concern about Australia's treatment of refugees and asylum seekers. We have recently criticised Australia's handling of riots at an immigration detention centre on Christmas Island and its pursuit of a bilateral agreement with Malaysia to exchange asylum seekers arriving by boat, which breaches the 1951 Refugee Convention. We deplore Australia's rejection of recommendations to end mandatory detention of asylum seekers. Despite Australia's contention that mandatory detention is based on unauthorised arrival, in reality all those who arrive undocumented by boat are asylum seekers and face indefinite detention. We further regret Australia's partial acceptance of recommendations on the detention of children in immigration facilities. According to the Department of Immigration and Citizenship, 1,048 children were detained in immigration facilities as of the 15th of April 2011. Mr. President, despite its stated commitment to safeguard the rights of refugees and asylum seekers, Australia's rejection of these key recommendations appears to signal a lack of political will to meet its international obligations in this area. Thank you, Mr. President.
Thank you. I give the floor to Save the Children International.
Mr. President, Save the Children welcomes the report of the Working Group on the UPR of Australia. We call on the Australian Government to address the following issues. Save the Children commends the Government for agreeing to explore a possible role for a National Children's Commissioner following Recommendation 29, but regrets the Government's decision, however, to only explore that role under the National Framework for Protecting Australia's Children. We strongly urge the Government to pass legislation before Parliament to establish a National Children's Commissioner who can represent and act on behalf of all children in Australia and its territories, including those in immigration detention, and not just Australian children suffering abuse or neglect. Recommendation 129 calls on the Government to ensure that no children are held in immigration detention. Although the Government aims to relocate some of the over 1,000 children currently in immigration detention, by the end of June 2011, Save the Children remains gravely concerned that the Government continues to detain children seeking asylum, despite its commitment under Article 37B of the CRC. We strongly urge the Government to immediately release all children and their families into the community, repeal the provisions of the Migration Act relating to mandatory detention, and enact legislation to ensure that no children are held in immigration detention, including in low-security facilities. Save the Children is disappointed in the Government's rejection of Recommendation 75, which calls on the Government to prohibit the use of corporal punishment within the family in all states and territories. This runs contrary to the Government's commitment under Article 19 of the CRC to protect children from all forms of physical and mental violence, injury and abuse. We strongly urge the Government to work with states and territories to prohibit the use of corporal punishment within the family and in all schools and alternative care settings. Thank you.
Thank you. I give the floor to Franciscans International.
Yeah. We appreciate the commitment expressed by Australia by setting up a Human Rights Commission, the decision to appoint 2 new commissioners to this, and its establishing a national action plan to help implement the recommendations it has accepted. We're encouraged by Australia's signing of the UN Declaration on the Rights of Indigenous Peoples and call on the Australian Government to implement fully its provisions. We recommend a fundamental rethink of the Northern Territory emergency response to involve all the Indigenous people affected through consultation and their active participation. We strongly endorse Recommendation 116 proposed by Thailand during the UPR and hope the Australian Government will make this a priority in its plan of action in closing the gap between Indigenous and non-Indigenous peoples. We express concern at the Australian Government's policy of mandatory detention for asylum seekers, whether authorised entrants or not, as a breach of its international human rights obligations. We urge them to lift the moratorium on processing claims by Afghan people. This unnecessary delay is threatening the mental health of detainees. We ask that the proposed bilateral agreement between Australia and Malaysia for the processing of asylum seekers and resettling refugees ensures compliance by both countries with international human rights standards. We call on the Australian Government to prevent the refoulement of asylum seekers to countries where their life is in danger and their human rights not recognised, as has been documented in over 100 cases. We urge the Australian Government to prevent asylum seekers being demonised in political debate and to cease trivialising human rights issues with expressions such as border control. Finally, we call on Australia to reconsider the impact of its carbon emissions on the exercise of human rights by the peoples of low-lying islands. If the Australian Government mitigates its emissions and puts a price on carbon emissions, it will help prevent future disasters. Thank you, Mr. President.
Thank you. I give the floor to Rado.
Merci. Monsieur le Président.
Thank you very much. The respect of the human rights of minorities is one of the priorities of a state with a rule of law. And this is why Australia has undertaken particular commitments vis-à-vis the indigenous peoples. Now, despite the onus of its history, Australia has undertaken a commitment to its indigenous peoples. It's a country that has been able to face its history and shoulder its responsibilities. Australia can serve as an example to other countries. Despite this, the fight to fight disparity between the Australian peoples is still a major challenge if we think about health, education and socioeconomic development. To this end, Rado believes it's very important to focus on local indigenous self-determination on the basis of programs which guarantee effective participation of indigenous peoples in economic, social, cultural and political life. We have to ensure that Australian legislation promotes a respect for human rights, that there is practical implementation of this on the ground, and that all of this is in compliance with international human rights standards. To conclude, Australia has fought all forms of racial discrimination against on the grounds of ethnic origin. We thank you for your kind attention.
Thank you. Unfortunately, we're running short of time, and so that was the last speaker that we could accommodate for this session. In accordance with established practice, statements that could not be delivered due to time constraint will be posted on the extranet of the UPR. I will now give the floor to His Excellency Mr. Peter Wolcott for his concluding remarks.
Mr. President. Australia would just like to thank states and observers and the NGO community for their comments this afternoon, which have all been duly noted. And I thank you. I thank you for this morning's session.
Thank you. I thank the Ambassador for his presentation and for the participation, the active participation of Australia in the UPR process. May I now propose that the Council adopts the decision on the outcome of the Universal Periodic Review of Australia as it appears on the screen. I see no objection. The decision is adopted. We will briefly suspend the meeting before proceeding with the consideration of the outcome on Georgia.